Hello and welcome. This was meant to be Wednesday's video, but we're doing it now. Before we jump into this video, I do want to go ahead and let you know I have two ways to donate to the channel. I have a Patreon account, which is a month-to-month monthly subscription system. But I also have a coffee account, which can do the same or allow you to do one-time single payments if you are so inclined. If you are in financial difficulty or it'll put you in financial difficulty, do not donate. I'd rather you be able to take care of what you need to take care of. Please. If you can afford it and you want to, thank you. I really do appreciate it. Because it's just me, myself, and I that make these videos. So yeah. With that said, let's get into this here. Before we actually start deeply into the video, I hesitated even making this. Right now, there's some antidepressants I have to skip, which keep me level. So, being off them for about a week now, it's been, yeah. Everything gets amplified as far as emotionally rage and sadness and yeah. And I was almost driven to do another attacking Trump video, but at this point, I can't do it. I'm not because I don't have the capability. I'm like, I need something else. I need to concentrate on something else because the pedophile in chief is driving me crazy, and I need some kind of regularity, something decent to pay attention to. And so I'll try to focus on this video. I haven't done one for the Supreme Court in a bit because honestly, like I said, I'm so fed up with the Republican Party and their pedophile in chief, and the fact that the current court looks nothing like a Supreme Court, looks more like a Supreme Clown car. But with all that said, we will go ahead and do this video. Last episode we looked at Chief Justice of this court, Melville Fuller. Today we're going to look at the first two associate justices to be added under the Fuller Court. And the first one is David J. Brewer. Oh, not that one. There we go. David J. Brewer, full name David Josiah Brewer. Joined the U.S. Supreme Court January 6, 1890, replacing Justice Stanley Matthews. Was born on June the 20th, 1837, in the Ottoman Empire, now modern-day Turkey, and where his father was a missionary. The family soon returned to the U.S., and Brewer grew up in England. He initially attended Wesleyan University, but transferred to Yale College, now Yale University, after 2 years and graduated in 1856. He then received a law degree in Albany Law School 2 years later and traveled west and eventually settled in the state of Kansas, where he held several judicial positions during the 1860s. In 1870, he was elected to the Kansas Supreme Court and was reelected twice to the seat and spent 14 years there. President Chester A. Arthur was then appointed Brewer to the U.S. Court of Appeals for the Eighth Circuit, where he served from 1884 to 1889, and on December the 4th, 1889, President Benjamin Harrison nominated Brewer to the U.S. Supreme Court. The Senate confirmed him on December the 18th in a 53-11 vote. So, pretty heavily accepted. There was only a few who were like, no, I don't like this nomination. So, and he took the judicial oath early the following month. His two-decade tenure coincided almost precisely with the era of Chief Justice Melville Weston Fuller, which, yeah, when did we say he got in? Oh, wrong one. Oh, nope, wait, maybe, nope, wait, maybe it's this one. 1889. And Fuller got in. When did Fuller get in? Uh, 1888. So literally the next year. And he's in there for the entire length Fuller is till 1910. So yeah, he's almost coincides perfectly with Fuller's court. The Fuller Court has gone down in history for its use of substantive due process to protect business interests. It joined the majority of the court, or he would join the majority of the court, in cases such as Allgaier versus Louisiana and Lochner versus New York, which both struck down economic regulations based on the freedom of contract allegedly provided by the due process law or clause. So, again, 1880s, early 1890s, Gilded Era. This is when we see the power of a lot of the original robber barons. J.D. Rockefeller, Andrew Carnegie, J.P. Morgan. I was like, call him J.P. Pierpont. And I'm like, no, that's not his name. Pierpont is his middle name. That's why they call him J.P. J.P. Morgan and Vanderbilt and others of the like. So yeah, it's not a surprise. By the late 1930s, the court had abandoned this perspective, however, as we had at that point hit the progressive era, and they were striking back against a lot of the regulation strike downs that the Gilded Era had brought. However, Brewer penned perhaps his most notable opinion in Muller versus Oregon, leading a unanimous court in upholding a state law that restricted the working hours of women. He based his conclusions on reasoning that sounds sexist to a modern reader, such as the fact that a woman has always been dependent upon man. Brewer also joined the court in key decisions, striking down a federal income tax and limiting the scope of the Sherman Antitrust Act. Yeah, the Sherman Antitrust Act did little because they tried to push it back to the background as much as they could. It did some good because there was still loopholes that had to be found so they could slip through, but yeah. He wrote for the court in a case that furthered racial segregation in education, although he often dissented from decisions in which the court ruled against Chinese immigrants. So yeah, this is one of the very racist eras of the U.S. You have the Asian Exclusion Acts. I think we're in effect at this point. And of course, we're post-Reconstruction, when you have suddenly any protections that had been given were quickly abandoned because the racists in the still pro-slavery South states pushed back enough that, yeah, things like the KKK suddenly had free reign. They had been around before, but they were kept in check because there was U.S. soldiers to hold them in check. We even had several African American politicians, but after Reconstruction, yeah, it didn't happen again until recently for some states. And then you notice recently we had the Supreme Clown car kick down and really almost completely undo the Voter Rights Act because they're a bunch of racist shits. A deeply devout justice, Brewer declared that the U.S. is a Christian nation in Church of Holy Trinity versus U.S. It's not if you read history. In 1892, like his descriptions of women in Muller, this claim has grated on modern ears. He would die March 28, 1910 in Washington, D.C. and was returned to Kansas for burial and replaced by Justice Charles Evan Hughes. Selected opinions they have talking about them. Muller versus Oregon, which dealt with due process, equal protection, labor versus employment, which in the synopsis here, the regulation of working hours of women falls within the police power of the state, and a statute directed exclusively to such regulation does not conflict with due process or equal protection clauses. Was the idea behind it. And then Hodges versus U.S., which dealt with labor and employment. A U.S. court has no jurisdiction under the 13th Amendment, which ended slavery, or other federal laws to charge other federal laws of a charge of conspiracy made and carried out in a state to prevent citizens of African descent because of their race or color from making or carrying out contracts and agreements to labor. Which, again, we know the era, the robber baron era, the Gilded Age, because, like today, only a handful of people got rich because they took advantage of workers. And so, yeah, you see where I'm going with this bullshit. And Shoshone Mining Company versus Rudder, which dealt with lawsuits and legal procedures. The mere fact that a suit is an adverse suit authorized by the statutes of Congress is not sufficient by itself to vest jurisdiction in the federal courts. So, trying to say, hey, just because it's something made in Congress, we can't do much about it if it's too disagreeable. Oh yay, let's see what oh yay has to say. We could find extra on virtually all of his professional life was in government service, moving from a moderate liberalism as a state judge to a strident conservatism as a federal judge. Surprise, surprise. Nominated to the High Court, 1889. Lived up to a reputation that preceded him to the Supreme Court. Active contributor to the doctrine of substantive due process. This is the notion that there are certain activities outside the scope of legitimate government. The effect of this doctrine would be to free activities from any government control. You know, like the morons who think less government is a better idea because we know what happens. The rich get richer and it fucks over the average person. But they're like, government power is oppressive. No, you're a shithead and you shouldn't have any fucking say. The doctrine was defined to the economic and regulatory sphere when Brewer served on the court. But the same doctrine has come to play a vital role in protecting individual liberties from government overreaching, which makes sense. That's how it should be used. Allow liberties, allow freedom. If you've ever watched some of my other videos, I'm all for legalizing all drugs, but regulating them. And what I mean, some drugs you can take, but they must be in controlled situations where you cannot hurt others. The opportunities to come to try to clean oneself from drugs should be offered. But, like I said, the dangerous drugs, allow them to take, but it must be in safe conditions where they don't hurt others or themselves. And there's some drugs I think people should just be able to take. You've got security in the room. They can just take the drugs, sit and watch TV, whatever, man. I know a lot of people be like, oh, it's not freedom. It's a lot more free than where we are right now. A lot more free. Same with prostitution. Legalize it, but regulate it. So that way you can't just have random killers going out and killing prostitutes because they're less protected. Because you would have prostitutes protected. They would be known. They would be able to get health checkups. As it sits right now, though, nah. It screws them over, their lives. So, yeah. I'm all about certain freedoms, especially when it comes to individual liberties. Business? No, screw you. Brewer may be best remembered for dissenting opinions. However, he spoke for a unanimous court in Mueller versus Oregon, 1908. Which was Mueller versus Oregon. Oh, talking about women's working hours. So yeah, it says the state can regulate the amount of hours women work because it falls directly under it, or it does not conflict directly with due process or equal protection clauses. So, not a not a great decision, but not a bad one. But David J. Brewer, married to Louise Landon, but she would die while they were married, and then he would marry Emma Mott. End up having 4 children in total. Yeah, Wesleyan University, transferred to Yale College / Yale University to earn a BA, and then earned his LLB, or his law degree, at Albany Law School. Served in the Union Army, reaching the rank of 2nd lieutenant. Also was part of Kansas's Home Guard. Was Kansas even a state at that point? Because that's what kills me here. It's one of the last states to become a state. Alaska and Hawaii were the very last, but Kansas was pretty far down the line. I'm trying to remember exactly when it became a state, but yeah. Okay. Kansas Territory. So it was still a territory at that point when he became a lawyer in Kansas. Because he received his LLB in 1858, but would move to the Kansas Territory because there was a gold rush at that point. But he wouldn't find gold and would settle down as a lawyer in Kansas. So yeah. David J. Brewer. Now, with him looked at, we will look at Justice Henry Billings Brown from Michigan, who was also pretty close in line with Fuller's, at least toward the end of his term, because he died ended his term in 1913 as a Supreme Court justice. Let's see. Justice Henry Billings Brown joined the Supreme Court January 5th, 1891, replacing Justice Samuel Freeman Miller. So yeah, remember, Fuller goes in to be Chief Justice in 88. Billings Brown joins 1891. Fuller would die as Chief Justice in 1910, and Brown would leave or die on the Supreme Court in 1913. So, again, pretty closely aligned in time frame. He was born March the 2nd, 1836 in western Massachusetts, graduated from Yale in 1856 and briefly studied law at both Yale Law School and Harvard Law School, although he did not earn a degree from either program. He was then admitted to the Michigan bar and started practicing law in Detroit. In 1868, he briefly served as a judge on the Wayne County Circuit Court and Michigan State Court in the Michigan State Court system. President Ulysses S. Grant appointed him to the U.S. District Court for the Eastern District of Michigan, a federal trial court, in 1875. He would remain there for 15 years, so until 1890. On December the 23rd, 1890, President Benjamin Harrison nominated him to the U.S. Supreme Court. So he jumped not only the state Supreme Court and the appeals court federally, but straight to the U.S. Supreme Court. The Senate confirmed him on December the 29th, and he took the judicial oath about a week later. He is largely remembered for writing the majority opinion in one of the most infamous decisions in Supreme Court history. In 1896 case of Plessy v. Ferguson, stood for the separate but equal principle that bolstered Jim Crow laws throughout the South for over half a century. The court repudiated it in 1954 with Brown versus the Board of Education, which mandated the racial desegregation of public schools. So 1896 to 1954, separate but equal, but we know that's bullshit if you've ever seen pictures of white water fountains and colored water fountains. Yeah. And they finally corrected it with Brown versus the Board. Brown retired from the court on May the 28th, 1906. Okay, so he actually left in 1906 and was replaced by Justice William Henry Moody and died September 4th, 1913. So he actually left before the two previous members, Fuller and Brewer, dying in Westchester County, New York, and buried in Detroit, Michigan. The 12,000 square foot mansion that he built on 16th Street in Washington, D.C. is now the embassy for the Republic of Congo. Interesting fact. Decisions he's known for. Selected opinions. Mifflin versus R.H. White Company, and it was dealing with copyrights. When there is no evidence that the publishers were the assignees or acted as the agents of the author for the purpose of taking out copyright, the copyright entry of a magazine will not validate the copyright entry subsequently made under a different title by the author of a portion of the contents of the magazine. So I'm assuming they're saying they copyright a magazine. It will not affect the copyright of something of the same name, like, say, a book. So, yeah. Or they may even be talking about the articles of said magazine. And dealing especially with apparently the authors of using the name. Westinghouse versus Boyden Power Brake Company. Even if the patentee brings the defendant within the letter of their claims, infringement could not be found if the defendant has so far changed the principle of the device that the claims of the patent, literally construed, have caused to represent their actual invention. So it's like, even if it's the same invention, as long as it's used for a different reason, they can still patent it. At least that's how I'm understanding it. Even if the patentee brings the defendant within the letter of their claims, infringement should not be found if the defendant has so far changed the principle of the device that the claims of the patent, literally construed, have ceased to represent their actual invention. So it also may be dealing with the fact of what it was originally patented for. And of course, Plessy v. Ferguson, a law that authorizes or even requires the separation of two races in public conveyances, is not unreasonable. This decision essentially applied rational basis review to what would now be considered a suspect classification that was overturned by Brown v. Board of Education. Yeah, Plessy versus Ferguson. Again, one of those horridly ridiculous Supreme Court decisions. Where is... right up there with Dred Scott v. Sanford. Under the Taney Court. So yeah. Both of them despicable decisions. I think Dred Scott v. Sanford was saying that even if they are in a free state, an escaped slave is still slave owner's property. Which, in and of itself, is complete and utter bullshit. Because, number one, slavery's a bullshit institution. That's all you need. You don't need any more. That's why I want to... calm down. That's why people like these Christian nationalists who think slavery is a good thing need a good kick in the ass. Because slavery is not a good thing in any form, matter, or fashion. And then Plessy v. Ferguson, separate but equal, man. No. Stupid versus fairness, man. Anyway, born in a small Massachusetts town, lived a privileged life. Good, though undistinguished as a student. Avoided service in the Civil War by hiring a substitute, which was an accepted practice in the day. Yeah, you could pay someone to serve for you. Quite literally. Held several government positions at the federal and state levels. Well regarded federal judge in Michigan. I'm assuming under the, what was it, Western District is where he was head of. Former senator and friend of President Benjamin Harrison, Hal Edmonds Jackson, urged Brown to be picked for the Supreme Court. And of course, Brown would return Jackson's favor by urging Harrison to bring up Jackson 3 years later. I'm not sure what position for, but yeah. You know, this is kind of how the good old boys club worked. He would author in excess of 450 majority opinions during his years in the court, and gave preference to private property claims, surprise, surprise, and defended free competition, free market principles. Also took a broad view of the state's police powers, including government restrictions on laissez-faire. Will probably forever be marked by a single opinion he authored for a majority, Plessy v. Ferguson. He no doubt reflected the view of his day that whites were biologically separate from blacks and that whites were superior to blacks as a group. Yeah. Unfortunately, very much the opinion, though nowadays we know that's stupid, and that there's people nowadays who have tried to go back to believing that bullshit. Again, they should have a kick in the ass. Let's see. Lee, Massachusetts is where he was born. Died Bronxville, New York. Proclaimed to be a Republican. Married Carolyn Pitts, who would die in 1906 while he was still on the Supreme Court, and then would marry Josephine Tyler 3 years later in 1904. So yeah, would earn his Bachelor of Arts from Yale and even attend Harvard University Law School and Yale Law School, but not get an actual law degree. But apparently they saw him as educated enough in law to practice. Grew up in Massachusetts and Connecticut, part of a New England merchant family, was well off. Entered Yale College at the age of 16, member of Alpha Delta Phi fraternity, and elected to membership of the Phi Beta Kappa. He had undergraduate classmates like Chauncey Depew, a later U.S. Senator from New York, and the justice we just talked about, David Josiah Brewer, who became his colleague on the Supreme Court. Depew roomed across the hall from Brown for 3 years and remembered a feminine quality about Brown, which led to him being called Henrietta by classmates at the all-male college. Eastern District of Michigan, where he was judge, which is a federal court, like the appeals court and others, but yeah. U.S. District Court for Eastern District of Michigan. Which you think Eastern District, that's where a lot of the bigger cities are in Michigan. I think Lansing is there. I know Detroit. I'm not sure if Ann Arbor would be considered an east. I think it's a little more south. I'm not sure if it's more to the west or east. But yeah. Married Carolyn Pitts, no children. We talked about him paying a soldier to serve in his place in the Civil War. Brown would keep diaries until his appointment as a federal judge in 1875 as the Eastern Michigan District Judge for the U.S. Those diaries are now in the Burton Historical Collection of the Detroit Public Library that suggest he was both genial and ambitious, so apparently friendly, but also sought something more, which of course getting help in the good old boys club tends to help out with that, but also depressed and doubtful about himself. As a child, he attended his family's congregational church, and when married to his first wife, accompanied her to a Presbyterian church. Though he was generally uninterested in religious matters, let's see, publishing and teaching, edited a collection of rulings and orders in important admiralty cases from inland waters, and later compiled a case book on admiralty law for lectures at Georgetown University. Also taught admiralty law classes at the University of Michigan Law School from 1860 to 1875, and medical jurisprudence at the Detroit Medical College, now the Medical School of Wayne State University, from 1868 to 1871. Received honorary doctoral degrees from the University of Michigan in 1887 and from Yale University in 1891. Satirical cartoon showing Justice Brown standing left center, so this is supposed to be Brown talking with Justice Harlan and Chief Justice Melville Fuller seated at the table writing a poem while the other justices discuss fashion issues pertaining to their judicial robes. So clearly, there's some people who didn't think very much of that Supreme Court. I wonder if they thought of the way I see this Supreme Court as a Supreme clown car. Let's see. was generally against government intervention in business and joined the majority opinion, Lochner v. New York, striking down a limitation on maximum working hours, but did support the federal income tax in Pollock v. Farmers Loan and Trust Company, and wrote for the court in Holden v. Hardy, which upheld a Utah law restricting male minors to an 8-hour day. So, there are some things he was alright on, other things it's like, no. Such as Plessy v. Ferguson. Personal life in D.C. He built a 5-story, 18-room mansion for $40,000, or $1,433,000 in 2025 money, and live in the house later known as Tortorsky Mansion until his death. It's now the embassy to the Republic of the Congo. Retired from the court in 1906 at the age of 70. In 1910, he presented a talk to the Ladies' Congressional Club of Washington, D.C. entitled Woman Suffrage. In it, he advocated against extending the vote to women, arguing that no persons, male or female, have a natural right to the vote, and that, for a litany of reasons, women should not have the legal ability to participate in elections. From the perspective of the 21st century, the talk is full of risible assertions and cliches about the role of women in society. Yeah. Like I said, we can clearly see there's some things he was alright on, but there's other things he had just horrible decisions on, views on. Let's see. Plessy v. Ferguson. The Chinese Exclusion Act was in it. I called it the Asian Exclusion Act, but yeah. But he would vote with the majority in the United States v. Wong Kim Ark that a child born in the U.S. of Chinese parents was a U.S. citizen under the Citizenship Clause of the 14th Amendment to the Constitution, which is known as due process, which the Trump administration willingly violates, even though it has been shown over and over and over that due process is something that must be fucking followed. Perhaps the public nadir of Brown's legacy occurred during the 2010 Senate Judiciary Committee confirmation hearings for then Solicitor General and former Harvard Law School Dean Elena Kagan to be an Associate Justice of the Supreme Court. She admitted that she did not know who Brown was, and her questioner, Republican Senator Lindsey Graham, oh dear May, of South Carolina, was then mentioned Brown with disdain. Senator Graham, and do you know, are you familiar with Justice Henry Billings Brown? Elena Kagan, I feel as though I should be, but I'm going to say no. Senator Graham. Well, you don't want him to be your hero. Trust me. Holy shit. Well, Graham's probably angry over things that he shouldn't be angry over. Not those that he should be angry over, because knowing how Lindsey Graham works, yeah. But yeah. And that gives us a good look at Henry Billings Brown. Woo! This has been a long one, folks. If you've stayed with me to the end here, I appreciate it. We'll go ahead and end this monster of a video. As always, educate thyself. Think, read, study, learn. Someone tells you something you have trouble believing. Ask them to cite their sources, and it can't just be tinfoil hat wearing sources or a bunch of anecdotes slapped together to try to make sources. I'll be putting my links and sources in the description box below the video. Thank you all for watching. I'll see you all in the next one. Until then, later.